Hello, everyone, and welcome to our webinar today. Substitute decision makers and handwritten wills is the subject of today's, or subjects of today's webinar. This is the first webinar in a three-part series for our 2022 estate litigation series. So I'm going to introduce myself and the two other speakers that we have today. I'm Alex Kotkas. I am a partner in the Calgary office of Fasken, and I practice primarily estate litigation, although I am also involved in some estate planning. Janis Ko is a trust and estate litigation lawyer in Fasken's Vancouver office. And Lily MacLeod is a lawyer in Fasken's litigation and dispute resolution group in our Toronto office. And so we're just going to launch right into the presentations today. What's going to happen is each presentation will be approximately 15 minutes, and we will then have a Q&A session at the end, and we'll try to keep this well within the hour that's been allotted so you can get on with the rest of your day. So our first presentation today will be provided by Lily, who is going to speak on substitute decision-making, powers of attorney versus guardianship. Take it away, Lily. Thank you.
Thanks, Alex. Welcome, everyone. Thank you for being here. Today, I will be speaking about substitute decision-making, an important and frequent issue becoming increasingly necessary, particularly within Canada's growing senior demographic. There are, of course, many challenges that come with aging, one of which is the potential for mental incapacity, including as a result of various medical conditions, including neurodegenerative disease. The concept of capacity, though, it is very context specific. There's different tests for capacity to manage property, capacity to make a will, capacity to make a power of attorney, or capacity for personal care. So in this presentation specifically, I'm focusing on the capacity to manage property, and specifically what happens when someone is deemed incapable of doing so. My presentation will review and compare the two main substitute decision-making options and processes that exist in Ontario specifically, which are continuing powers of attorney for property and guardianship applications. So I'll explain what these options look like from a practical perspective and highlight the benefits of proactive planning where possible. So individuals with complex or high net worth assets can benefit from signing a continuing power of attorney for property to avoid things like familial disputes, stress, time, expense, and litigation. So today, this is a quick overview of what we'll be talking about, and let's dive right into it. So there, as I mentioned, there are two avenues for substitute decision-making as it relates to management of property. The first being a continuing power of attorney for property. So that's a written document that creates an agency relationship where one person, the grantor, gives to another person, the attorney, or multiple people, the authority to manage their property on their behalf. So the grantor chooses someone or multiple people they trust to make such decisions in the event they become incapable of managing property, or if they're even just unavailable when important decisions must be made or actions must be taken on a timely basis. So the key principles here are really choice and flexibility. So when the grantor is capable of doing so, they can, for example, name an alternate attorney in the event that the attorney they choose to be their primary attorney becomes incapable of continuing to act for them. The grantor can add in restrictions on the attorney's powers to manage property. The grantor can indicate when the document takes effect specifically and how incapacity is assessed. And having the ability to make those decisions in advance avoids much stress, time, and emotions often that can arise when people don't take these actions in advance and a guardianship is required. So a guardianship this happens in circumstances where somebody becomes incapable of managing property, and it's necessary that someone does manage their property for them, but they haven't signed a continuing power of attorney for property. So what happens is a guardian must be appointed by the court following an application being filed and a hearing taking place. This process is far more time consuming and costly than signing a continuing power of attorney for property, even when the application is not contested. So for example, a parent may bring an application for their adult child who has a permanent developmental disability. Even in those circumstances, it's quite expensive. And when the application is contested, so for example, there's multiple applicants like family members who both believe that they are the proper guardian to be appointed, or the public guardian and trustee doesn't approve the application, the stress, time, and cost multiplies. And ultimately, the person doesn't get to choose who their guardian is, and it's not clear always whether the appointment aligns with their desires. So just from a practical perspective, attorneys and guardians must act unanimously. They must make decisions jointly, and some institutions will require sign-off from all substitute decision makers, even in person. So logistically, if you're thinking about signing a continuing power of attorney for property or bringing a guardianship application and naming multiple substitute decision makers, you might benefit from asking questions about whether the people know each other, do they get along, do they live close by to one another, because I've seen that create issues from a practical perspective. So each of these avenues comes with different rights, powers, obligations, standards of care, and exposure to liability. And they both require sort of different appointment processes. With respect to continuing powers of attorney for property, the Substitute Decision Act governs both continuing powers of attorney for property and guardianships, and it sets out certain requirements for a power of attorney. So in terms of the grantor needs to be capable of giving a power of attorney at the time that they make it, within the meaning of Section 8 of the Substitute Decisions Act. So that's actually different from being capable of managing property. It becomes very confusing because there's many different tests for capacity. But in the case of when you're asking, does somebody have capacity to actually sign a power of attorney, this means they must know and understand the property that they own, their obligations to dependents, the various powers that a power of attorney grants to an attorney, the attorney's duty to account, the revocation rules, and the risk of loss from the actions of the attorney. That's sort of the test that they need to meet to be able to sign one. And just a couple of formalities. An attorney needs to be at least 18 years old, and they can't actually witness the document. In terms of form, it doesn't need to be in a particular form. Often a lawyer, of course, can prepare one, but it must expressly be referred to as a continuing power of attorney for property. There are different types. So on the one hand, there's a general power of attorney for property, which means that the attorney can make decisions with regards to all property. And then there's specific powers of attorney. So the attorneys can only make decisions with regards to specific property that the grantor owns. And then there's limited or unlimited power. So limited, of course, means that the attorney only has certain powers, whereas unlimited means that they can do anything that the grantor could do with their property if they were capable. I briefly touched on appointees. Sometimes people would like to appoint more than one person, but we need to think from a practical perspective how that will work in terms of them acting unanimously. A big issue that often arises in litigation is the method for determining incapacity. So it's helpful when you sign a document like this because you can actually indicate when it comes into effect, and specifically the test for determining, or the method for determining, when someone's incapable. So if it doesn't actually set out the test, there's a section in the Substitute Decision Act, which basically says that the person needs to be assessed by a qualified capacity assessor. There needs to be 2 witnesses, and certain people are not qualified to be witnesses. For example, as I mentioned, the attorney can't witness, the grantor's spouse or partner can't witness it, the grantor's child, or somebody who's under a guardianship. And now in the COVID world, there's been amendments to the legislation so people can sign these documents virtually if certain requirements are met. And continuing power of attorney for property can be terminated in multiple situations. So, for example, the attorney could die or become incapable. And that's why it's helpful sometimes to name an alternate attorney who can act in the event that they pass away. So there's continuity. It can be terminated if a court appoints a guardian or a person signs a new power of attorney. Somebody revoking their power of attorney and signing a new one can often be very contentious because it sometimes happens in situations where the person arguably doesn't have capacity, and that can become very litigious. So that's an issue to be wary of. Just practically, if you're an institution and a third party advises that they're an attorney, for example, under a continuing power of attorney for property, it's helpful to ask, of course, for an original copy of the power of attorney. Check that it was validly executed. So was it signed by the person? Was it properly witnessed by two different people? Does it meet the other formalities? And a key issue can often be whether the attorney currently has authority. So sometimes the document will say that it takes effect immediately upon signing, meaning that the attorney can act as soon as the document's signed. Other times it says that the attorney can't act until the person becomes incapable. So that's something to check. And if it says that the person can only act if the grantor becomes incapable, an important question to ask is, have they participated in a capacity assessment? And if so, do they have a copy of that? And if not, then if the attorney is saying that they have capacity to act, even if the grantor has not lost capacity, it's probably prudent to ask to speak to the grantor themselves before allowing the person access to documents. Moving on to the appointment process for guardianship. So if there's no continuing power of attorney in place and somebody becomes incapable of managing property, there's two ways that an individual can be appointed as a guardian. I won't get into the details of statutory guardians. It's less common, but basically the public guardian and trustee can become a guardian in two different ways, which is when somebody's in a psychiatric facility and a certificate of incapacity is given under the Mental Health Act, or a person may request that an assessor performs an assessment of another's capacity. And when that assessment is given, the public guardian and trustee can be appointed as a statutory guardian. These can also be terminated, and the public guardian and trustee can be replaced. The more common process is a court-appointed guardian of property. So again, this happens in situations where somebody doesn't have a power of attorney and their property needs to be managed, and any person can apply, and a court will appoint a guardian if the person is found to be incapable of managing property. And as a result, it's necessary for decisions to be made on their behalf by a person who's authorized to do so. So the court must make a finding of incapacity in order to appoint a guardian. Generally speaking, this whole process will require that the person or people, typically a family member, let's say an adult child for an elderly person, or a spouse, files a court application with supporting affidavit evidence from the proposed guardians, indicating basically why they're fit to act as guardian and are able to act in the person's best interest. There'll also need to be evidence regarding incapacity to manage property. That the best form is in the form of a capacity assessment, and also a management plan, which basically sets out how the guardians, their plan for managing the person's property, and that must be approved by the public guardian and trustee. The public guardian and trustee and a number of other family members must be served with the materials and given a chance to respond. And the public guardian and trustee will typically write a letter with comments, or in some cases appear at the hearing if there are real issues, and then the court will make an order. So as you can appreciate, this is extremely lengthy, time-consuming, expensive process, and when it's contested, it becomes even more so. Moving on to the rights and powers. Guardians and attorneys have many of the same rights and powers under the Substitute Decisions Act, but the rights will really depend on whether there's restrictions in the power of attorney and also any restrictions in the court order. But if there's no restrictions, both substitute decision makers have extremely broad powers, and that's why it's so important to consider planning in advance. By way of example, certain rights, guardians, attorneys, they have the right to complete a transaction, for example, that the person entered into before becoming incapable. They also have the ability to demand that a person who has custody or control of the person's property provide that property to them or provide any information about that property to them. In terms of powers, as I mentioned, assuming there's no restrictions in the documents, a continuing power of attorney allows the attorney to make decisions over a person's property as if they were the individual themselves. So the attorney has the power to do anything on behalf of the grantor except make a will. So in this case, a will includes testamentary dispositions, such as designating the beneficiary of a life insurance policy, RSP, TFSA, but it's very broad, this authority. And is only really limited by, again, any restrictions that are written in the power of attorney document, as well as the fiduciary duty, which I'll talk about, statutory duties under the Substitute Decisions Act, and the common law. There are certain optional expenditures that a attorney or guardian can make, and then there's certain permitted. So for example, an attorney or a guardian can make gifts or loans to the person's friends and relatives, as well as charitable gifts. Limitations, the big one, as I mentioned, is really just that the attorney cannot do anything in terms of making a will or making a document that is akin to a will. They also cannot dispose of property that they know is subject to a specific gift in the person's will. But those are really the only main restrictions. There's no specific restrictions set out in the statute about bank accounts or investing. It's very broad, the authority that the person has. Regarding the next point, which is obligations, both substitute decision makers are fiduciaries, and that's their overarching duty. They also have specific duties that are set out in the Substitute Decisions Act, which again are generally the same. So they are fiduciaries whose powers and duties shall be exercised and performed diligently with honesty and integrity and in good faith for the incapable person's benefit. That is the main overarching duty. And it's also important to note that if a particular decision that they make will have an effect on the person's comfort or well-being, they must consider that effect in determining whether the decision is for the incapable person's benefit. They also must manage a person's property in a way that's consistent with decisions concerning the person's personal care. So from a practical perspective, when you're considering signing a power of attorney or you're considering bringing a guardianship application, think about the relationship between the attorney for property and the attorney for personal care, because they will often need to make decisions together. And if those two people don't get along, for example, they are siblings, which I've seen happen before, that can become extremely difficult from a practical perspective to get things done and to agree on things. So that's something to consider. Just by way of example of some of their duties, of course, it makes sense logically. The attorneys and guardians, they have to explain their duties to the grantor and encourage the person to participate in decision making, even though, of course, they've been assessed as incapable of making those decisions. Still important to involve them in the process. They need to foster contact between the person and their family and friends. As I mentioned, they need to consult with the personal care attorney for personal care or guardian for personal care, as well as the person's friends and family and caregivers. A big important obligation is keeping accounts of all dealings with the grantor's property. That can become a very labor-intensive process, and it can be important to get legal advice on how to do so in a way that is proper, because often the court will make an order requiring the guardians to pass their accounts, meaning basically bring an application showing that the guardians are keeping proper accounts and managing the person's property accordingly. So that is one of the biggest duties from a practical perspective. And when you become an attorney or you become a grantor, you become a guardian rather, it's important to just start making inquiries, like determining whether the person has a will, and if so, what the provisions are. And ultimately, the expenditures that are actually required to be made by the guardian and the attorney are those that are reasonably necessary for the person's support, education, and care. those that are reasonably necessary for the support, education, and care of the person's dependents, and those that are necessary to satisfy the person's other legal obligations. So those are quite broad. A particular obligation that does not apply to attorneys but does apply to guardians is this requirement to prepare and file a management plan. So that's part of a guardianship application. And as I mentioned, there's a specific form that you use, and it really sets out in detail what all the person's assets are and how they're going to be managed. And it needs to be approved by the public guardian and trustee. Quickly moving on to standard of care, I will just note here that the standard of care will depend on whether the person's being compensated. So if somebody decides to seek compensation for acting as a guardian or attorney, the standard of care is higher. And finally, exposure to liability. I just note here that it's important to consider when you are considering whether to accept this position, you can be liable for damages resulting from a breach of your duty. But this can be mitigated if the court is satisfied that you acted honestly and in good faith. But something to consider because it is a big role. So ending finally on just reflecting on why it's important to draft a power of attorney. We've talked about this, but ultimately, really you have the choice. You have the choice to plan how you want your property to be managed, and that's an empowering process. Cost and time, big cost savings and time savings because guardianships are extremely expensive and they can become very protracted, especially if they're contested. Flexibility, I've talked about this, but they can be drafted in many different ways. A power of attorney giving you the ability to limit your agent to certain assets or time, and you can appoint multiple attorneys or alternates. And it really prevents delays in having your assets protected. So it provides continuity. That concludes my presentation. I will now pass it on to Alex, who will cover handwritten wills, gifts that give, but not as you intended.
Thank you, Lily. That's excellent. Great. Well, I wanted to address this topic today because I am seeing a fair number of handwritten wills in my practice, and they come across my desk typically, sometimes for an ordinary administration without too many issues, but often with issues. And so if we can go to the first slide, please. Really, I think handwritten wills are something that the legislation allows somebody to do, and there are circumstances where they're appropriate, but really they're intended because there are emergent circumstances where people should be able to make a will, but they don't necessarily have the ability to easily access a lawyer, take the time to type up a will, get it properly executed, and consider the issues. And so, they're really not meant for everyday use. But frankly, they are in everyday use. They're very common. And what I'm seeing and have seen throughout my practice is that, you've got highly educated people, very successful, wealthy, capable people who I think have spent their lives being frugal and also believe that their estate issues are very simple. And so as capable people, they believe they're quite able to get behind this issue and get it done without the assistance of a lawyer. The reality is, of course, that they may well be able to do that, and their estate may be as simple as they think. And if we can go to the next slide, please. I think, what we're all trying to achieve is to benefit our loved ones with our estate. We don't want to put money in the pockets of lawyers, the government, or large companies. We don't want to see our hard-earned assets going to anyone other than our loved ones. And unfortunately, handwritten wills frequently are a false economy. You save a little bit of money up front by not having a lawyer prepare your will, but you end up often benefiting the wrong people and financially costing ultimately your loved ones far more than if you had consulted a lawyer at the outset. And also you can unintentionally create emotional rifts and turmoil within your family that can have long-lasting impacts. And so, this is the kind of thing we wanted to avoid. Having said this, handwritten wills are very popular. We're not going to be able to convince people not to do them. So what I'm going to do is run through some of the things that people should have in mind when doing them. And as we go through this list, please keep in mind that if even one mistake is made on any of these items, that will cost your estate dearly. If there's a court application required, even if it's for something relatively straightforward, that obviously benefits the lawyers, the people you don't mean to benefit. We're doing fine. We don't need you to do that. So please keep that in mind. You also don't want to create unnecessary tax situation that can cost your estate or benefit companies in the form of typically an insurance company that would provide the bond that is required in some circumstances. For example, when you have an executor that's out of province. So let's start with validity issues. These are the first thing to keep in mind, of course, is whether you're actually writing a valid will. And that takes some research to see what's required in your jurisdiction. In Alberta and many other provinces, a handwritten will that is signed, as long as it's in the testator's own handwriting, is valid. But in British Columbia, it is not. You have to have some formalities in British Columbia. And in Prince Edward Island, they also do not recognize an informal handwritten will. And so you've got to research this and figure out whether you're even writing an effective will. There are some common pitfalls as well to avoid with respect to validity, and that is you can't have any portion of the will typewritten. It must be entirely in your own handwriting. Your signature must be below all of the text. Some people want to add a postscript or remember something later and they add it in below the signature. That creates problems. You can't make revisions to the will. We don't know when they were made or who made them. You effectively have to start over. And then will can be rendered invalid in some provinces by marriage and in other provinces by divorce. And so you've got to understand the legalities around whether you're making a valid document. The next topic to consider is some of the simple mistakes that people make when drafting a handwritten will. And that is often people forget to date the document. And this creates confusion because there may be an earlier handwritten will or a later handwritten will that you make. And it's not clear then which one is in effect. And so simple mistake, but you've got to date the document. Also, did you remember to include in writing in your handwritten will that you're revoking your earlier wills? If not, we get into a dispute about what is the governing document. Does this will just add to or supplement the earlier will, or does it replace it? And there can be some confusion around that, again, costing your estate unnecessarily with the dispute that can arise there. The next issue is gifts to children. Gifts to children, of course, are the most common after the gift to a spouse in a will. But have you considered what happens if your child dies before you do? And unfortunately, that can happen, of course. And who should get their share then? It's easy if they don't have any children. You would say, well, it should be shared amongst my surviving children. But what if your child that passed away before you, ends up passing away before you, did have children? Often people want those children, the grandchildren from that child, to receive that share. And of course, they may not have children at the time you write the will, but they could have children before you pass away. And so you've got to take that contingency into account. And if we come over to the next slide, the other consideration, if grandchildren are receiving, is at what age would you like them to receive their inheritance? The law will give it to them at age 18. Many of us don't want that. Many of us feel that our own grandchildren, as much as we love them, may not really prepared at age 18 to receive a significant sum of money. So now you've got to deal with the staging of the distribution. And the question is, are you comfortable wordsmithing all of that and dealing with all of those contingencies in your handwritten will? Do you want to take the time to wordsmith that and make sure that you don't make any of those costly mistakes that are very easily made when you're preparing a handwritten will? The next issue to consider is what property is part of your estate. So, there is a distinction between property that passes within your estate and outside of your estate. Much of the property that all of us own is held jointly, typically with a spouse, sometimes with a child, sometimes with a business partner. A lot of that property, if in certain circumstances, will pass outside of your estate. Real estate, for example, bank accounts, investment accounts. Similarly, your RRSP or RIF has likely been left to a beneficiary. Often people have opened those accounts many years prior, and when I ask clients, do you know who the beneficiary is, they very often look at me blankly. And that's just because it's been so many years since they opened those accounts. So going over to the next slide, the question becomes, what assets are actually going to pass through your estate? The joint assets will pass outside. And that means that your estate doesn't necessarily have all of your assets in it. And the danger is that you left gifts in your will you thought your estate could afford. But because a lot of your assets have passed outside of your estate, in fact, your estate doesn't own that property or doesn't have enough property to be able to make those gifts. The next topic is to consider, of course, is tax matters. We can't avoid tax. And if you're doing a handwritten will, you should have a general understanding of the tax consequences that apply on your death. Capital gains tax, of course, is the main issue here. And you may have a spousal rollover available, but of course your spouse may predecease you. So you're going to have to face capital gains tax at some point if you've had a gain in your assets, as many people have by the time they've reached an elderly age. There are some tax exemptions that are available. Do you understand what all those are and what the tax consequences are for your estate? Because again, these can affect the size of your estate, and they may reduce the value or even eliminate, in some cases, the value of a gift that you thought you were giving in your handwritten will. But the tax consequence impacts that gift. The next item to consider, of course, is your executors. Often people think this is a relatively easy choice, and it may look easy, but if the executor resides outside of the province, you would generally have to provide a bond. They would have to provide a bond in order to be able to become your executor. And there is an application available to waive the bond in certain circumstances. But either way, you've cost your estate unnecessarily if you have, because the application itself is expensive, the bond is expensive, so either route costs your estate. And you, to the next slide, please. The options are costly, and the bond fees will go typically to an insurance company. The court application fees are going to go to us lawyers, all unnecessary. And if you can choose an executor that is within the province, that's a far better choice. Also, you have to consider alternates. I see many cases where the chosen executor, for a number of reasons, cannot be the executor or is not prepared to be the executor, often due to ill health, perhaps they've moved, many situations. Again, you need to wordsmith in alternates. It's just more work for you to put into your handwritten will, but it's got to be done if you want to avoid difficulties down the road. The next item to consider is the nature of the gifts you give. Have you taken into account the longer-term consequences of the gifts you're giving? Many people want to give equally to their children as an alternate to their spouse if their spouse is still alive. And that's the most common. Of course, that's normal and natural. But I always have to ask the question of whether they've treated their children equally during their own lifetime, that is the testator's lifetime. Over to the next slide. And the question is, if you haven't treated your children equally during your lifetime, and many people haven't for various reasons, you can cause hard feelings to develop. And maybe you don't do anything about that, and maybe you do. Often children have been treated unequally because they aren't all the same. Some have struggled more in life than others. Others have had success or even wild success, and they don't need the help. But if you've treated them unequal during their lifetime, even if there are reasons for that, and you then treat them just equally in your will, that can create resentments. And not in every family, not with every situation, but it's something to think about, to talk about, and often what I encourage people to do in order to avoid the issue is to equalize the treatment of their children during their lifetime, so that then when they give an equal gift in their will, it's received well, and there isn't any risk of resentments being created. And those resentments can make life after your death for your loved ones quite unpleasant. We can go to the next slide. The other topic is debts owed to you, whether by family members or others. Often we have debts, loans we've made to our children, maybe tax-free or interest-free, loans. Not everybody has this, but many do, to encourage them in a business or what have you. Have you thought about how those loans are to be dealt with? Are they going to be forgiven? Are they going to be deducted from the gift in the will? Recall that there is no presumption in this regard, the requirement that they be paid back immediately. So you've got to think about whether you've got that sort of situation outstanding and how you want to address it. Probate fees are the next topic. In some jurisdictions, Ontario, for example, probate fees are very significant. They are not in Alberta. But do you understand in your jurisdiction what the impact is of probate fees? And what have you done to minimize or avoid those fees if you can? There are various strategies that can be used to minimize or avoid probate fees. It depends on your circumstances. This is a topic that requires some substantial research and planning if you want to avoid probate fees, if they're significant in your jurisdiction. As I say, they aren't here in Alberta, but they are in other places in Canada. The next topic to consider is the clarity of the words that you're using. Any confusion or uncertainty can require a court application to resolve or create a dispute amongst your family members. This can come at it will come at a significant expense. Some people really feel strongly they want to leave a particular piece of real estate to a particular loved one. And I always say, well, you've got to be very specific about that. I usually encourage people not to do it for a number of reasons. But often when at the time you write your will, you may own a particular home. But do you mean to reference the home you own now, or the one that you may own at the time of your death? Or you may not own that home at all anymore, because often, if you live to a ripe old age, you've moved out of that home and you're into some kind of care facility, or you moved in with a family member, or what have you. So if we go to the next slide, please. I encourage people not to leave specific pieces of real estate. But the other issue that arises there, if they want to, is that there are often mortgages on real estate. And that creates a problem, because you may not be giving the gift that you thought you were. Many years can pass, the mortgage may be reduced, or maybe you had to increase it. But really, it's very difficult to give equally if you're giving specific pieces of real estate, because often the mortgages or the value of that real estate may change. The other issue is percentages in the will. I certainly don't encourage those. Moving on to the next slide, gifts to charity. The issues that can happen here are that people choose a charitable name that is very similar to other names, and that creates confusion and even litigation. None of us want to see our gift to a charity going into litigation. The next topic is the use of parting words or wishes in your will. Often people confuse their will or feel the need to add parting words or wishes because this is their last words. That is very dangerous. That creates confusion. What do you mean to be directing in your will, and what are you really just wishing? Another problem that creates confusion. The next topic has to do with claims, potential claims against your estate. If you have minor children, have you dealt with your dependents appropriately? If you've gone through a divorce, what obligations have continued from that? Have you addressed those in your will? Over to the next slide. Blended families create a whole other category of issue, and there are many blended families. Some people have a particular way they want their estate to pass when they're in a blended family situation, and that can be structured. Again, this is not something that is well done in a handwritten will. The next issue is property owned in another jurisdiction. An array of issues arise in that situation, tax and legal and otherwise. The next topic is whether you've considered alternatives to even having to go through probate. There may be a way to avoid probate altogether. And if you research that or get advice from a lawyer on that, you may be able to avoid even having to go through the process. And also think about gifting your loved ones during your lifetime so that you can see them enjoy the benefit of the funds while you're still around. So in conclusion, although I understand the desire amongst many people to be frugal and avoid legal expense and believe that their estate is simple, it may not be as simple as you think. And often a handwritten will is a false economy. One wrong step can lead to very expensive consequences. And that's not the legacy that any of us want to leave our loved ones. So those are my comments, and I will pass it over now to Janis, who will speak on when substitute decision makers abuse their powers. Janis.
Thank you, Alex. So my presentation is the second half of our talk today on substitute decision makers. While in Lily's presentation you heard about what substitute decision makers are and how to appoint them, my presentation will focus on how to deal with substitute decision makers when they abuse their powers. So as you learned in the first part of this talk, the powers granted to substitute decision makers are extensive. They can do anything on behalf of the adult whose finances they are managing that the adult can do, except for a few things, including making a will, designating beneficiaries under the will, and appointing another attorney. Given such extensive power, substitute decision makers must act in the best interests of the adult. While most will be honest and act in good faith, there will be many who do not. And the reality is that many of them will get away with it. But in the cases where abuse is discovered or suspected, there are remedies available. In this presentation, we will talk about substitute decision makers' duties to the adult, the remedies available when abuse occurs or is suspected, and the role of the public guardian and trustee in supervising substitute decision makers and protecting the interests of vulnerable adults. In BC, substitute decision makers their duties are set out in the Power of Attorney Act for attorneys and for court-appointed guardians or committees, as they are called in BC in the Patients Property Act. Substitute decision makers, as you heard, are considered to be fiduciaries. And so they must act in the best interest of the adult. They must also maintain good records of the transactions that they perform on the accounts of the adult whose finances they are managing. They must not use their powers for financial gain by accessing the adult's accounts to pay for their personal expenses or transfer the adult's property to themselves. And they must not intermingle the adult's finances with their own. Next slide, please. Most abuse of power cases involve attorneys appointed under power of attorney. This is because committees or guardians are appointed by the court, and as part of the order appointing them, they are required to account to the public guardian and trustee. So they are supervised by the public guardian and trustee, whereas attorneys are not. They are required to account if the adult requests an accounting or if they are ordered to do so. But otherwise, there is no third party who is supervising what they're doing with the power of attorney that they've been given. In BC, if abuse is suspected, a report can be made to the PGT under the Power of Attorney Act, or to a health authority under the Adult Guardianship Act. With reports to the health authority under the Adult Guardianship Act, this is mostly to deal with situations where an adult is being physically or emotionally abused or neglected, while reports to the PGT are mainly to deal with financial abuse. Next slide, please. So Section 34 of the Power of Attorney Act provides that any person may make a report to the public guardian and trustee if the person has reason to believe that an adult is being abused by an attorney, or there are other issues with the appointment of the attorney. Next slide. If a report is made to the public guardian and trustee under Section 34 of the Power of Attorney Act, the public guardian and trustee must promptly review the report to determine its validity. And if after reviewing the report, they determine that it is a valid report, then the PGT will take steps to investigate the report. In the course of the investigation process, the PGT can interview witnesses, they can demand and review documents, and they may, in some cases, freeze bank accounts or file caveats on property to prevent the adult's property from being dissipated. Next slide. Oh, sorry, go back to the previous one. Thank you. After the PGT completes its investigation and determines that there is some abuse that's occurred, the PGT may apply for various orders, including orders under Section 36 of the Power of Attorney Act to remove the attorney, or it may take steps to be appointed as the committee or the guardian of the adult under the Patients Property Act, or to become the statutory property guardian of the adult under the Adult Guardianship Act. Or if the PGT determines that there was no abuse, then they may do nothing. Where financial abuse is suspected, the court can order that a substitute decision maker provide an accounting of what they've done with the adult's finances. And these orders are usually made against attorneys because committees, as I mentioned earlier, are required to account periodically to the public guardian and trustee. When it is determined that abuse is occurring, one of the most obvious remedies is to remove the attorney. And this is available under Section 36 sub 5 of the BC Power of Attorney Act. If the PGT concludes that there is financial abuse by an attorney, it may seek the removal of the attorney. Alternatively, if the PGT doesn't act, decides that there is no abuse and does nothing, the person who reported to the PGT may apply under Section 36.5 themselves to seek the removal of the attorney. In the case of a committee, if there is abuse or suspected abuse, the PGT or another interested person can apply to replace the current committee. The case of BC PGT versus Ferrier is an example of an egregious abuse of power by attorneys. In this case, the attorneys used the power of attorney granted to them by their mother to access her bank accounts and pay for their own personal expenses, and even tried to pay off, one of them tried to pay off his own personal mortgage in the amount of $451,000 and his line of credit using the mother's money. And this was likely the red flag that caused the bank to make a report to the PGT. After the hearing, the court determined that these attorneys were using the mother's funds as though they were their own, and ordered the termination of the power of attorney and appointed the public guardian and trustee as the mother's committee. Another order that the court can make against a substitute decision maker is for the repayment of funds taken from the adult. In the case of Sull and Pengelly, the adult had Parkinson's disease. She was in a wheelchair. She could not move without assistance. She needed help bathing and dressing, and she could barely talk. She communicated with facial expressions and gestures. And during this time, while the mother, this adult mother, was suffering from this debilitating disease, her attorney daughter used her power of attorney to access the mother's accounts and spent over $300,000 on her line of credit, her credit cards, and her accounts, and had the mother transfer her property, her home, to her as a joint tenant. This was not, in this case, this abuse was not discovered until after the mother passed away. And so this wasn't a case where the PGT was asked to intervene. In this case, the person who intervened was one of the beneficiaries of the mother's estate, who applied for standing to make a claim against his sister, the attorney, for the breach of her fiduciary duty, and to seek the repayment of the funds that the sister had taken. After the trial, the court ordered that the attorney daughter pay her brother, the other beneficiary, the amount that he would have been entitled to if based on a notional repayment of all the money that the attorney daughter had taken from the mother's accounts. In cases where substitute decision makers transfer property to themselves, the court can also order that the transfer be set aside or reversed. Section 27 of the Property Law Act expressly states that attorneys cannot do this. They cannot transfer the grantor's property to themselves. In the case of Galloway and Barsky, the attorney daughter transferred her parents' property to her son to hold in trust for her in order to circumvent Section 27 of the Property Law Act. The court found that the daughter breached her duties as attorney for the parents, and ordered that her son transfer the property back to the parents. And so in conclusion, while the reality is that most financial abuse by substitute decision makers, especially attorneys, will go undetected, if abuse is discovered or suspected, you or your client can make a report to the PGT or to the health authority, and hope that the PGT will handle it. If the PGT does not intervene, decides that there's no abuse, or that if there is any discrepancies, it's not enough for them to take action, the person who made the report can apply to revoke the power of attorney themselves. Or if the adult who is suspected of being abused lacks capacity, then you or your client can apply to be the committee or guardian of that adult. Or alternatively, finally, if the adult is deceased and the abuse is only discovered after the adult passes away, then in BC, a person can apply to the court under Section 151 of the Wills, Estates and Succession Act to make a claim on behalf of the adult's estate to recover any assets that were improperly taken by a substitute decision maker. One final note is that if, in this case where after an adult has passed away and someone is seeking to recover property based on there being abuse, if the PGT had already concluded that there was no abuse, then it makes this type of claim more challenging. You have to overcome that determination by the PGT, but the claim can still be made. And that concludes my part of the talk, and I will hand it back over to Alex for our Q&A.
Thank you, Janis. That was terrific. So I'm noting the time. We don't have too much time left for the Q&A, but we will still address, we'll just go a little bit over time so that we can address a question each from each of us speakers. And The remainder of your questions, we are happy to answer and will answer if we haven't already answered them during the presentation. So feel free to provide us with contact information if we don't get back to you immediately, and we'll be sure to get responses out to you to those questions. So Lily, one of the questions that was asked had to do with whether capacity is assessed differently in different contexts. And the question specifically says if the person was thinking about giving a gift or contemplating a gift, but their capacity was somewhat affected, for example, by Alzheimer's, then would that be different, assessed differently than if they wanted to make a will, for example?
Right. Thanks, Alex. That's a great question. And I briefly alluded to this in my presentation, the whole idea that capacity is extremely context specific and fluid in general. So the question that you should be asking when you're in a situation where somebody's capacity is at issue is capacity for what? There's different definitions of capacity depending on the specific action or behavior. And most of those in an Ontario context are set out in the Substitute Decisions Act. So people can be capable of making one kind of decision, like making a gift, for example, or generally managing their property, but not be capable of something else, like, for example, making or changing their will, because those are different tests. And the courts have said that testamentary capacity is not necessarily a higher bar than the capacity to manage property or the capacity to make a power of attorney, but they are just simply different tests. So it's quite nuanced, and it can be confusing because there are, 5 to 10 at least different tests for these kind of things. But as I mentioned, the first step is really capacity for what? What are you looking at? It could be, somebody wants to make a power of attorney or they want to revoke their power of attorney. It could be in the context of we need to seek a declaration that a person is incapable of managing their property for a guardianship. It could be, does somebody have the capacity to consent to a specific type of treatment, or do they have the capacity to consent to being admitted into a care facility? So the first step is really figuring out what is the proper question that you're asking. And then once you identify the type of capacity at issue, often the best approach is to contact a qualified capacity assessor directly and request a capacity assessment. The Government of Ontario website includes a list of qualified assessors in different regions of Ontario. And if you're interested in the qualifications, you can check those out in the Substitute Decisions Act. But ideally, the person will voluntarily submit to that kind of assessment. But if they're not willing to do that, you do have the ability to apply for a court order permitting an involuntary assessment. And ultimately, if you get that order, if the person does consent to an assessment, an assessor does have the ability to assess for different kinds of capacity. It doesn't have to be just one. And they'll write a letter with their conclusion that speaks to the factors in the Substitute Decisions Act. Just practically speaking, the assessors will set their own rates. They can be several $100s, but it depends on the region. And you can take a look at their qualifications before you contact them. And in terms of if they're legally binding, the assessment, the decision can be legally binding. For example, if they do an assessment to determine whether the public guardian and trustee should be appointed to make a person's financial decisions for them, that will be legally binding. And just from a practical point, if you're thinking about things like if you're somebody's substitute decision maker and you do want to get an assessment and it is expensive, it's helpful if someone writes in their power of attorney to begin with that those kind of fees for assessments can be reimbursed from the incapable person's property. So that's another benefit of doing that in advance. So generally, capacity assessment's the golden standard, but if you're doing, for example, a guardianship application that's not contested, sometimes the court would accept something like a letter from a GP. I've seen that happen before, but you're sort of rolling the dice on that. So hopefully that answers your question. It's a complex topic with lots to it, but that's I think the general takeaway is it is very context specific.
Thank you, Lily. Janis, there was a question asked about when you have an attorney that's no longer able, maybe they've passed away themselves, they're not capable, not willing, no longer able to continue as the attorney, what is the process for replacing or substituting an attorney?
That's a good question. I think the first step to try to transition that substitute decision making to the PGT is to contact the PGT and to make that report and ask if they are willing to step in. The adult will have to be found to be to lack capacity to manage their own affairs, and this will have to be based on the medical opinion of at least 2 doctors, and I think that's what Lily was mentioning in her answer. And in some cases, you'll have an adult who clearly lacks capacity but is unwilling to be subjected to a capacity test. And in BC, it's not clear whether a person can be forced to be assessed. In BC, there's been case law where the courts declined to make that order. There has to be some evidence, some prima facie evidence that there is some capacity issue in order for the court to exercise its parents patriae jurisdiction to make that order that the person be assessed. The application for the PGT or anybody else to be appointed as a guardian or a committee should be brought as a petition, where the PGT is asked to act. If there's a family member who is more suitable and who is willing to act, the PGT may not take on the role, but they will make recommendations as to what terms should be imposed. For example, how often that committee or guardian should report to the PGT with their accounts. Usually it's something between 6 months and 5 years, every 6 months or every 5 years for an accounting to be provided. The public guardian and trustee continues to supervise the person who is appointed as committee, as long as the person is still under the committeeship.
All right, thank you, Janis. Good. Well, the question that was asked in one of the questions asked in respect of handwritten wills was whether, if you have a formal will already in existence, can you modify that with a handwritten will? And the answer to that, at least certainly in Alberta, is that you can. So both types of will are valid. If you have a formal typewritten will that's been executed before witnesses that was in existence, you can do a handwritten will that would revoke that formal will. You can modify what's in it, effectively doing a codicil, and address all of the things you can do by a formal will, you can do in a handwritten will, even if you have a formal will in existence. Again, there may be issues with doing that. You'd want to run through some or all of the considerations that apply to you that we've talked about today, in order to avoid, trouble down the line, that expense you don't want to have to incur and trouble you may create. But you certainly can do it in terms of a legal ability. So thank you. There's several other excellent questions. Thank you for the thoughtful questions submitted, and thanks everybody for attending. We have our second webinar in this 3-part series that will be coming up on October 28th. The topic for that webinar is a tongue-in-cheek name. It's how to ensure your estate is squandered by litigation. Obviously, nobody wants to do that, so it's tongue-in-cheek, but that'll be the topic there. If you want to register for that event now, there'll be a link in the chat that you can use to do that. And for any other upcoming events, please visit our website, and then there's a Fasken Institute section on the website that will direct you to upcoming events. So thanks again, everybody, and thanks to Janis and Lily for your efforts and your presentations today.